it makes sense for board members to have a dialogue with Mr. Bassett's attorney relevant to settlement. Any thoughts on that?
Could I speak on that again?
Sure, absolutely.
Mr. Mabel, we're in a tough situation right here, all right? In 2006, things were a lot different. We made a decision, this board made a decision, to protect our executive director and chairman. Things have changed since 2006. And we're in a position right now where we're in the process of trying to get out of this contract. There is no easy way. You know, I'd like to say, oh, we could hire a big team of lawyers and solve all our problems. Teams of lawyers haven't solved very much for us over the last year. And I'm looking at the contract. I read it over again and again this weekend, and I honestly don't think that there's any easy way out of this. Spending money on lawyers at this point is just, you know, I mean, if somebody in the room needs to say, I told you you were wrong, okay, I was wrong, you know, so be it. But just because I'm wrong, it doesn't mean that I have to continue to be wrong. Let's resolve this now and get it over with, you know. At the end of the day, the way I look at it, the worst case scenario is that we would pay Mr. Bassett approximately $300,000 between now and 2012. So with the shape of the contract, I think that's going to be inevitable. So what I'm looking at is if a subcommittee of the board or the board can meet with his attorney and try to resolve this and move on, you know, without spending more money hiring additional teams of lawyers to make it from $300,000 to $500,000. You know, let's cut our losses. Let's, you know, we can call Martineau the dope for signing that contract, and let's move on. You know.
First of all, we certainly times do change, and decisions are made in the moment, and so let's not reflect on that and let's move forward. How about this suggestion? We ask Mr. Mertz and Mr. Martineau to have a discussion with Mr. Bassett's attorney, and in the interim, we also collect letters of engagement letters from law firms so that we're positioned to make decisions if we feel like that's not proceeding in the right direction. We have a meeting in 2 weeks. I would say to you I have no problem with taking additional vacation time to have subsequent meetings if they need to happen every week rather than every month to get this done. It'll allow you to proceed to having some discussion. I certainly, unless there's strong opposition to that, but I think on a parallel track, in case we bump into a circumstance you no longer feel comfortable about that, we are prepared to hire legal counsel so that if it goes to arbitration, we're going to need one anyway.
Okay.
So any thoughts about sort of that compromise, where we allow 2 members as a subcommittee to begin that dialogue, and at the same time we, Mr. Morse and I, as examples, go off and try to get letters of engagement of law firms who haven't previously worked for the board, who may have an interest and expertise relative to these kinds of matters, and report back on that in 2 weeks. Thoughts about that? Ms. O'Leary?
That's fine.
Mr. Mertz?
Sounds good.
I got a problem with that. How much groundwork would a new firm have to do that's already been done by this law firm, in the sense that researching all the way back to with the contract and all the other things that go back to '06 and before that and all the rest of it, work that's pretty much been done by this firm, I don't think it would have to be done over again. And we're talking cost here, and I think that's an issue that I think could be very expensive.
I'm not sure that I understand your law firm's involvement is that you would have specific information relative to Mr. Bassett's performance prior to this discussion in the last meeting. Am I incorrect about that? Have you been involved in other disciplinary matters involving staff here at the board?
Well, we have represented the board on matters since August, so during that period of time we have dealt with all members of the board and the staff. We have not conducted a special investigation of Mr. Bassett, aside from dealing with PIRAC from time to time on specific matters. Of course, we've read the PIRAC report and understand it. One suggestion I have, just to, for the next 2 weeks only, is if in fact it would help us to give some assistance to the two members authorized to negotiate. After all, ultimately, even if you reach a dollar figure, if you can, you need to have a document that appropriately protects the board. Now, Casey and Lundergan, as general counsel to the board, can also look at that or draft that document, or we can, but that wouldn't require the engagement of new counsel, and that would speed matters up. In addition, I would have some suggestions in terms of negotiation, some of the risks and rewards of both sides to take into account. Again, the board can do this on its own as well.
Again, I'm focusing on two things. One is the duplicative nature of having general counsel and special counsel. Special counsel, and I understand, law firms are fairly broad in terms of their areas of specialty, focusing first on questions of whether or not PERIC had the right to appoint the chair, and now on matters of personnel. We seem to be broadening relationships. I think there'd also be questions relative to, again, not questions, and I don't take this in a sort of professional derogatory manner. The reality is you have been involved with the board, and I think part of what we're trying to do is separate relationships so folks don't say, well, you had an ongoing working relationship. This board did hire this firm. Mr. Bassett was the executive director and chairman at the board of the time you hired this particular firm. Having them involved in a settlement discussion or any kind of discussion relative to a personnel matter, I think, is inconsistent how I would see the board moving forward and raises the kind of questions we're trying to avoid. In addition, we have general counsel. I think your comments is exactly correct. They will need some guidance. They will need some direction. If we're fortunate enough to strike some kind of a chord, they certainly will need a very specific direction and instruction. I would see that if we're going to, have general counsel here, then we either raise the question of why general counsel's here. Again, no disrespect. I sat in a meeting discussing sort of the open meeting law discussion, and you folks were commenting on it. And I had general counsel. I was sitting in the audience, and general counsel isn't weighing in on it. We don't need two law firms at the same time making decisions or interacting with one another to make decisions. It just seems to be, I keep on repeating myself, duplicative, which is a good word to be using in repeating yourself. So it seemed to me that we have counsel in place. That counsel can work with these two board members. I respect the work you've done for the board, but I don't think this is the appropriate role for it at this point. That's my own position on it. I would ask that the board decide to craft a motion on how best to proceed. And we'll go from there. I'll entertain motions.
I would put my...
Excuse me.
Sorry. That was good timing. That was good.
This is the second thing.
Fast forward isn't good.
Mr. Chairman, I put my topic of discussion into a motion that we form a subcommittee and pursue resolving the contractual issue with the former executive director and chairman.
Inclusive in that motion, we'll be working with some counsel relative to that, or how do you would like to proceed?
I'm a fiscal conservative. I'd be prepared to, do it and come back to the chairman with some sort of a proposal for the board to look at, and if they thought it needed recommendation.
Would you be including another member of the board with that?
Yes, Kevin Mertz.
Mr. Mertz, is that amenable to you? I guess we'll find out as part of a discussion. Do you have a motion? Sorry, didn't mean to. I have a second on the motion.
I'll second that.
Motion made and seconded. All those in favor?
Aye.
Aye.
Opposed? Do we have 4-0 or 3-0 and 1? Is there? I just didn't hear you, Mr. Morrison.
I didn't say anything.
Okay. So we have an abstention?
It's an abstention.
Okay, on the discussion of hiring legal counsel or obtaining engagement letters and background information for legal firms, we have a motion relative to that.
I will make that motion that we go forward and